Okay. Let's hope this is working. Let's hope this is working. I'm in a different place today. I'm recording the live. Let's see if this is working. Hey, everybody. Hey, Queen. Let me move this. Hey, Queen. Okay, we're late. We are late because we were doing more HR Armor community stuff. So we late, but now we're getting started. Welcome. We're streaming on 2 different places, and I am standing up this time because my legs hurt. So, hey, everybody. Hey, welcome. Welcome here. Happy that you're here. Happy that you're here, even though I'm late. But let's try to get this started. Let's try to understand what is going on today. This is HR Armor. I'm Noël. So all things discrimination, retaliation, hostile work environment, toxic workplace, anything dealing with your workplace, I am your go-to person to talk about workplace defense strategies and what you can do when work turns hostile against you. So you tell me what's going on and I will be happy to answer. And again, I want to be looking back and forth because I have 2 screens coming on because we're streaming in multiple locations right now. So I'm going to try to track and try to follow who has comments, who has questions. Today, as far as hanging out with me, what I want to talk about is workplace investigations. I posted something a little bit earlier today about workplace investigations. And for anybody who has been in a workplace investigation, this will all make sense because it all has to do with the investigator and what the investigation actually is about, how the questions are posed, how you answer the questions, what you do say, what you don't say, how you say it. Because anything that you say inside of a workplace investigation can 100% be turned against you, but it can also set you in another direction so that you are not held responsible and you are not held accountable for something that was never your fault to begin with. There's a lot of people who say that they do workplace investigations, but they are not so-called trained in investigatory tactics, so they don't fully know what to do and what not to do and how to present the case. So again, it all depends on what your job is, what you're being investigated for, what evidence is being presented against you, and actually knowing your rights. So whenever you all are being questioned about anything in the workplace, make sure before you start to speak that you understand what your rights are. There's always some kind of company policy or some kind of diagram or some kind of disclaimer or disclosure. There's something that you are either presented in advance or should be presented before you start to speak to inform you of what your rights are. So just make sure that you are well aware of that before you start talking to the investigator, speaking to HR, even speaking to your supervisor if what you are going to speak about could potentially be used against you in a disciplinary action or in something adverse. You want to always make sure that you know exactly what you're going to, like how it could potentially be held against you before you start to speak about it. Okay? So I just wanted to put that out there up front because a lot of people are messaging me and telling me like they have an investigation coming or they just finished an investigation and they're like, what do I do? What do I say now? And I'm like, well, what did you say already? And what were the questions? And they have no idea what the questions were. They have no idea what the so-called investigator wrote as far as a statement, as far as taking their statement, as far as the investigators' notes themselves. So they have no idea what their actual rights are and what they can do. So it's always, again, just to reiterate for everyone who's joining, before you start speaking to an investigator, before you start speaking to your supervisor, before you start speaking to HR, just know what your rights are. Do you have to speak at the time? Can you follow up in writing instead? Do you truly have a right to remain silent, which is the 5th Amendment? So what exactly are your rights and the moment at that time before you start disclosing or before you start sharing with the investigator, okay? All right, cool. So I got some questions coming in, but that's all. I wanted to just start by that, right? Because people are always like, what do I do? What do I do? So now I just told you, make sure you know what your rights are. Make sure you know what your rights are, and not that they're just reading you what your rights are, but that you have the actual document that explains what your rights are, be it a policy, procedural manual, some kind of form that they give you to sign or to read over before you start disclosing and sharing stuff. Just make sure that it's very clear before you start. All right, so here's the question. Noel, I sent you an email really fast, but I just been stressed out and you didn't respond. Okay, well, send me an email again. Listen, if you need me, I am there. And I usually respond to, so I don't know what email you sent that to, but I usually respond to emails like crazy fast because I know how things move. So I am actually really good at responding to emails. So please send me an email. Again, make sure it's going to my right email address. My email is open to clients or people wanting to be a client. If you are not a current client, and if you are an HR Armor member, post in the community, the HR Armor community, tag me at Noel and I will make sure I respond to you, okay? If you're not in the community, why aren't you in the community? If you're not a member of HR Armor, why not? Because truly it's not just for defense, it is for any situation in the workplace, not just for when you are in trouble, but also before you get in trouble, or before they try to say you're doing something that you haven't been doing, or before you make a protected disclosure, or before you go on FMLA, or before you go in an extended leave status. So join before it happens too, okay, everyone? Not just at the time that it happens, you're like, oh, I need help now. Like, seriously, be a little bit more proactive and get protected before you actually need protection. Please, it'll save us all some stress and some energy, and make sure that we are doing everything that we can to make sure that we protect you, okay? So how you join HR Armor, the question is, you go to hr-armor, armor.com/links, links, and that's how you can reach me. That's how you can work with me one-on-one. That's how you can find out how to get inside of the community and get all your questions addressed. Okay, other question. If they started retaliating against me after I submitted a complaint 3 months ago and didn't get a reply, okay? If I follow up on the response, is that a mistake or does it look reactive? So, good question. I think following up on a response after you submit a complaint really depends on what the procedures are at the company itself. So I'm saying that for a reason, right? Because if they tell you, oh, you can just submit it through the hotline, or you can just email it to your supervisor, that's all good and great. But a lot of times there are timelines attached to that process that you need to be made aware of before you start the official complaint. Like I'm about to put this up. So before you put in an official complaint, which means that you need to know what the timelines are from whatever incident to the time that you're reporting it, whether that reporting has to be done in writing, or whether that reporting can be done verbally, or whether there's an official form or format or method, whether that's an email, a hotline, some other way of submission. Like I've seen it where there's like an employee box, like a physical box where you have to put it in the box for it to be considered. So it really depends on what the company policy is. It also matters if you're in a collective bargaining unit. So if you have a union involved, so what does the master agreement say? What does the bargaining unit agreement say? What does the actual procedure say for you to submit that complaint? Because you got to make sure that you're submitting that complaint in the method and the way and the means and the timeline that it should be submitted, or they won't consider it to begin with. So after you make sure that you've submitted the complaint properly, once it is submitted, make sure that you also know when the response is required to be returned to you. Because if they are supposed to respond within 5 business days, 10 business days, and they don't, then you have grounds, then you have leverage, then you have a way to respond to them and ask them for an update based on a policy. So there's a difference of just inquiring as to what's the status versus inquiring as to what's the status based on policy 907 of June 2025. You understand what I'm saying? Does that make sense? I hope that's making sense, right? So there's a way to request an update based on a procedural aspect instead of just based on an inquiry itself. That is a part of the strategy, and that's why strategy matters, because if you respond or if you request an update which may be premature, or if you request it in a way that is not skillfully, I don't want to say languaged. Is that even a word? Language? But you understand what I mean, right? But if it's not articulated in a way that they would understand what your question is, then they may take offense to it. And if they take offense to it, then they're going to belabor it even more. But if you tether them to policy, you tether them to procedure, you quote the policy, you quote the procedure, you reattach what you've already submitted, and you're like, hey, based on the policy, I'm inquiring as to the status, and you can further add how it's impacting you in the workplace. It is impacting me. I'm unable to concentrate. This behavior is being exasperated. There's a lot of situations that continue to compound what I have already filed a complaint about. I am looking to get a speedy and expeditious resolution, or at least to begin the process so that I am protected in the workplace. Then you can quote the policy. Every company has a policy on anti-discrimination, anti-harassment, a workplace free of workplace violence, all that stuff, right? So you can quote the actual policy, even not specific to the procedures of filing a complaint, and quote that and use it as leverage. Use that as leverage and say, hey, based on X, Y, and Z, I am further bringing this forward in hopes to a speedy resolution. So that's how you get them to respond, right? So remember, first things first is understanding what your rights are by understanding what the policy is. If you don't know what the policy is, then ask them for the policy. You have a right to know what procedures are in place that govern your employment. Period. You got a right to know. You got a right to know what's in your employee file. You have a right to know what the policies are. You have a right to know what the procedures are. You have a right to know what your rights are at work. And if you don't know, then ask them. Ask them and find out. Again, you want to make sure you are tethering their words to them, because if it goes to some place, like some type of administrative grievance or administrative procedure or some type of the claim of discrimination, a claim of retaliation, if it ends up in district court or MSPB, you want to make sure that all of your documentation, all of your exhibits are tethered to policy, are tethered to procedures, are tethered to something that is tangible and not subjective, something that they cannot say is up for interpretation. That's how you move the investigation forward. That's how you move your complaint forward to make sure that you are protected in the workplace. So I hope that makes sense. I hope that makes sense, right? And if you ever want to go deeper, again, seriously, if you ever want to go in deeper, because my one-on-ones are finally open, I am accepting clients. So just send me an email, or better yet, go to hr-armor.com/link. Links. The link is in my bio as well, and you can find me that way. You can find me to do a one-on-one, but if you're not able to do that kind of investment, that is okay too. You can still join HR Armor itself and have full access to all the defense intelligence. Remember, and I don't talk so much about this now, but I need to do it again. That is access to the defense intelligence that I built, that each engine is over 1,500 pages, single space, single line of knowledge that I poured into every single engine to help you navigate situations in the workplace. So again, you don't have to navigate this alone. I got your back, whether it's one-on-one or whether it's through the intelligence engines. I even created an HR Armor app. Yes, it's on the App Store. Yes, it's on Google Play. No, you can't sign up yet if you haven't already been a member, but we're still working on that technical difficulty. But it's up and it's running, and the app is real, and you can take it with you before you go into the meeting. You can take it with you at work. I mean, it's a real bona fide app with all the defense intelligence integrated inside. So again, if you're not inside the community, join at hrarmor.com, okay? All right, so back to questions. So good question about complaint, good question about investigation. I hope that helped where it needed to. I hope it landed. And if you need, again, more technical assistance, then you know how to reach me. All right, question. Let's see. All right, Patricia, here we go. My HR just fired me, but I had already warned them that I would file with EEOC. They fired me. They fired me a week after they got the charge letter. Okay, so they fired you after they got the charge letter. What did you do then? And what did your complaint with EEOC says? And it's such a great question, Patricia, because what I am actually seeing is people are filing EEO cases because they have the capacity to file, which means that they see the form on the website, they fill it out, and they file it and say, I'm good, I'm protected. That is such a terrible move. Not saying that's what you did, Patricia, but overall, what I've seen in my own experience being 30 years in executive HR and also running HR Armor and helping people navigate this, I've seen the worst entries. I mean, I don't even know why EEOC honestly is accepting it this way, because I just think it's a true disservice, but they are. But I've seen the worst entries because people are just putting what they believe from their heart as to how they were discriminated against, but the case is not as strong as it could be. I'll give you a prime example, right? One of my clients, he has an actual attorney. He has paid multiple thousands of dollars with this attorney. Okay, this attorney wrote his EEOC charge letter, and he's like, look, Noel, I've been trying to get stuff from the attorney. The attorney's not responsive. I wish I hired you sooner, but can you just take a look at this? I was like, okay, right. Well, this is now a one-on-one. So he's already a technical client of mine. So now I'm looking at what his attorney said. So he sends me what the attorney said, and I'm like, wait a second. I don't think you attach more pages. Like, I think there's pages that are missing, because I'm just thinking there's more pages missing, because there's just no way. In my mind, I'm like, there's no damn way that your attorney charged you this much money for this piece of paper. There's just absolutely no way. Based on everything that you just told me that's happening right now, there's no way that that's all that your attorney wrote. And he's like, oh, was there supposed to be more? And I'm just like, oh my gosh. And it's not just him. Like, the number of clients that I am receiving who have attorneys who are turning in paperwork to EEOC, calling them charged documents, are just abysmal. EEOC is not going to take that and move forward with it because it's not supported by facts. It's supported by feelings, and the feelings doesn't have anything of substance to it. There's no meat inside of the document that would make any counselor say, uh-oh, there's some there, let's investigate this truly. There's no there. I mean, the document was terrible. It missed out all the major aspects that he could have claimed as far as discrimination, just based on our conversation alone, that the attorney missed. So I would just say it again, just because you can file an EEOC based on filling out the form doesn't mean that you should without strategy or without structure or without knowing your rights. You got to know what your rights are. You got to know what the structure is, and you got to be ready to proceed forward. You have to make sure that you can do that, because otherwise, like, it's just not going to work, and they're going to deny it, and nothing is going to go forward from there. It is going to be a disservice to you, okay? And also double check on what your attorney submits too. Don't just let your attorney submit something without you reviewing it. And especially if you're paying for an attorney or anybody, right? Ask the questions. Don't be afraid to ask questions. If something doesn't make sense, and like if you feel like the hairs on your neck, right, or like the hairs on your arm, or you just like, trust that. Like, trust your gut feeling with this. Don't be like, well, just because it's an attorney and they have the label of attorney, they're going to do me right. That's not the case. And I've just seen it happen too many times. It's happened to me personally. Like, I'm talking from my own experience. I know what you're going through. I know how it feels to put your hard-earned money and trust in somebody in a process, and then they let you down. I know personally how that feels. Trust me. So I am telling you from my own experience and from seeing it from the side of the employer, ask questions. Don't be afraid to ask questions. There's a difference between accusing something or making accusations and asking a legitimate bona fide question. You're inquiring. That is authorized, it is allowed, it is permitted, and you should expect nothing less from yourself. Ask the questions and get the answers. Okay, so back to, again, filing with EEOC. So if they fired you a week after your charge letter, you can always add that to your claim, so you can amend your claim as further acts of retaliation if you believe that it's connected to the reason that you filed, if you believe that it's connected to your discrimination, if it's your protected classes, if you believe it's connected to a complaint that you filed, if you believe that there's some kind of connection. Again, we're talking temporal proximity. Again, that means the time that something happened and the time that an action happened after that. So if you said, hey, supervisor, the law says you got to do this, next thing you know, you're on the PIP because you made that protected disclosure, that could be considered temporal proximity, okay? So all of that can be added to your claim of discrimination, even if you've already filed. You just got to find the way to amend the claim. Just know this, going into it, you want to go in the strongest position possible. You don't want to go in with the mindset of, oh, I'm just going to amend it. You don't want to do that. The law is very strict on timeliness. It's really strict on criteria. You want to go in there with your best foot forward, with the most information you have, to be like, this is what I got. You can't say anything else because this is what I got. This is how I'm connecting it to the law. This is how I'm connecting it to case law. This is what the courts say about this. This is what has happened to other people who resulted in this action. And this is what they got as a result of that. So there's a lot of ways to skillfully navigate that. And again, this is what I help my clients to do, even when they have an attorney. Like, again, back to my one client who I was talking about earlier, what I wrote to him. So my deliverable after our one-on-one session, I always deliver a document, right? My deliverable to him was, pages and pages, just because it was just so much freaking stuff. What he did was, which I don't always want people to do, but he did it, whatever, it's his product. He sent it to his attorney. He sent my work product to his attorney, and his attorney turned around and tried to amend the complaint, take my name off, and attach my work product to what he did for the client, and charge the client for doing the document again. I'm laughing because you can't make this up. You can't make it up. So not only did the attorney failed him, but he used my work product, attached it to his work product, and then charged the client for refiling and amending the complaint for something he should have got right the first time. But see, again, that's the difference. That's what attorneys don't do. They don't strategize. They're not a strategic architect. That's what I do. Attorneys look at the law and how to file and all that stuff. I architect it. I show you what's underneath, what's in between, what are angles that were not considered, how to navigate it, how to say it skillfully, what process should be done in an exact sequence. Think about it like this, right? I don't know if you guys remember, but I'll just give this analogy. Remember, like in the old days when you would be going out and you would be getting people's phone numbers, and you'd be like 917-334-2843 or whatever, right? It'd be phone numbers. So you can have all the digits, but if you put them in the wrong order, you're never going to get through to the person, right? So you can have all the phone numbers you want, but if you don't put them in the right order, you'll never reach what's on the other side. That's the same thing that I do, because you can have all the information in the world as to how to navigate a situation, but if you don't put it in the right sequence, it's never going to come out in your favor. It's just not. The system is very skillful, right? The system always protects itself. Remember, HR protects the company. Your supervisor protects the company. The company's lawyers protect the company. The board members protect the company. All these leadership entities, people in charge, protect the company. They got like departments that protect the company. And who do you have? So that's why I'm here, and that's why I do this. I don't do it because I have to do it. I do it because I love to do this. I love to give employees what they've never had, is that protection in their back pocket. So again, we're gonna get back to questions. I know we run a little bit over, but I just want to make sure that that is clear, that again, you all know how to find me if you need my support. You know how to reach me. Everyone needs somebody in their corner and on their side. And if you have made a mistake, trust me, I'm going to be the first person to tell you, because I don't just sugarcoat. That's not what I do. I follow law, rule, and regulation. That's why I'm successful at what I do, because that's what I do. So if you didn't do something right, you want to be told that wasn't a smart move. Like, I'm going to be real up front. I'm not just going to say stuff just to say it. I mean, that's just not what I do. Okay. So I hope that answers your question. Okay. So for that EEOC, you can still amend it. You can try to amend it. And especially if there's some kind of temporal proximity, if you think it's a connection to the reason that you were fired and that they fired you because you filed a complaint, let that be a part of your complaint. Let that be you standing up to be like, I see what you did, and I'm going to make sure it doesn't happen to me. I'm going to make sure it happens to nobody else. And I'm going to make sure you guys pay. I'm going to make sure you pay for what you did. All right. Instead of just going and trying to find something else and moving on. No, make them pay. Make them pay for violating your rights. Why not? That is your right to do. And I think everyone should execute their legal rights 100%. All right, here we go. Question. Let's see. Here we go. All right, they played a game and now they're mad because I played it better. Now they have 4 charges. Exactly, good. Now they have 4 charges. Good for you, Patricia. Good for you. So keep them honest. Keep them honest. Get all the documentation together. Get all the paperwork together. And make sure that they are, again, treating you fairly. Treating you fairly, not treating you a certain way because how you look. Because how you speak, because where you're from, because of your religion, because who you're married to, or if you're not married. I mean, don't let them just treat you a certain way just because they think they can, right? So hold them honest and hold them accountable to that. I absolutely support you 100%. I'm glad that they admitted the charge. You're amazing for doing this work. I didn't know I have a paralegal background. You're doing this alone. I'm glad I found you. Yeah, I'm glad you found me too. And I'm happy that you're doing it pro se. Not everyone can do it pro se as far as their capacity. And I say that from a person who's done that multiple times myself. Like, it just takes a lot. It does. It takes a lot from you. It takes a lot as far as your family. But are the awards and the rewards a hell of a lot worth it? Absolutely. Absolutely, to know that you stood your ground and you did what's right based on your laws, rules, and regulations to make sure that they were not violated and make sure that you were protected in the workplace and you were holding them accountable for the policies and procedures that they had that were not applied equally and consistently across the board, but were only applied to you a certain way because of how you look, how you sound, who you're married to, or any other characteristics that's protected by Title VII. 100%. And remember, everyone has the capacity to be their own attorney. You don't have to have gone to law school to be your attorney, to advocate for yourself. You don't have to spend your life savings to get a lawyer to advocate for you, especially because lawyers can't guarantee outcomes. I can't guarantee outcomes. All we can honestly do is put our best foot forward and do what we can in the best interest of you all as a client. And I know for me, all I can do is make sure you got the strategy you need to make sure that you didn't need an attorney to begin with. And if you do have an attorney, to make sure that you are holding them accountable to what they claim that they're going to do for you. So that's what I do. That's my whole spiel for today. I got one more, One more thing to, we got one more, what is this called? One more place to go live on. So I'm going to end one of them here. There's one more question. I'm sorry, how do I reach you? I filed 2 formal complaints with the Division of HR, need more guidance. Okay, so go to hr-armor.com/links. That's how you find me. It's in my bio, is at the top. So that's just the website, right? You go there, you pick whatever situation applies, and I got you. That's how you reach me directly. I respond to every single inquiry, okay? So again, even if you cannot afford the investment of having a one-on-one, that's totally okay. You can still get inside of HR Armor, where we have the defense intelligence that I built myself. Remember, for you guys who've been with me since we started this in October, November of last year, I built these engines myself with all of my knowledge docs put inside of it. Like, I literally built it with my own hands and my own experience into these documents and into this intelligence. So you can absolutely join HR Armor membership so you can get access to that defense intelligence. The difference between those are you navigating the community, you get access to me, you have Zoom sessions and groups with me as well, where we can talk about your situations. I respond to you in the community. But as far as you navigating the situation, you are navigating through self-guiding, right? So you're using the intelligence, which is like you're talking to me literally, but you're using that to help you. Whereas one-on-ones, I'm looking at every single document. I'm responding to every single letter that you're sending me. We're doing literally one-on-one. This is what you do. This is how you do it. Like, again, people are telling me I'm worth the weight in gold. Check out the client wins. I'm trying to put it up there. Like, it's hard in this business because no one wants to say their name, because a lot of them are still dealing with the situation. Even if it's been resolved, they're still with the company based on my support. So they're like, I don't want to say my name. I'm like, I don't care what your name is. Like, you can even join the community and call yourself Mickey Mouse, Donald Duck, right? Cat in the Hat. Like, for me, it doesn't matter at all. I just want to make sure you guys are protected and you have exactly what you need when the work turns hostile against you. So that's what I got for now. I will see you guys next time. Remember, podcast is dropping. I'm recording first episode tomorrow. I recorded the pre-teaser. This thing is fire. So that drops next week, but the official podcast drops on May 31st. I'm excited to share. And I'll keep you guys posted as that evolves and as that develops. Okay, so we will talk soon. Send me a DM, send me a comment. Let me know what you guys think. Let me know if there's some other kind of topics you want to talk about. I'm happy to indulge, especially during the Hangout with Me sessions, because there is no agenda. We just talk and get stuff done. So I will talk to you guys next time.